Hi there, and welcome to another edition of the Employment Law Show right here. John Scholes and Lior Samfiru joining you each week and making you that much smarter when it comes to workplace rights and employment law is a topic you may not know anything about, or if you've been watching this show for years, listening to our radio shows even longer, you may be well educated, but there's always something new in the show, and I want to tell you what we're going to talk about in just a little bit. Common myths about termination process. That's on the way. Anytime you want to reach out to Lior and the team, simple, 1-855-821-5900, help@employmentlawyer.ca. We'll try to get to some of your emails on the show over the next half hour. And there's always the website. It's free. It's anonymous. You'll have access to so much knowledge, including the severance calculator. That can be found at pocketemploymentlawyer.ca. And some phone calls from our radio shows coming up on the show today as well. But a week that was, case of the day. What is going on with you, pal?
Hey, John. Awesome to be here. Want to talk about employment law. Want to try to resolve as many workplace issues as possible. That's the name of the game. You have questions. We have solutions. We have answers. We have information on this show when it comes to those workplace rights that you have. Because guess what? You have rights. You have entitlements. You have options. There's things that you can do if your rights have been violated, if your employer is not treating you properly, if you lost your job, if your job is changing. The law can address all those things. The problem, of course, which is the genesis of the show, is that there's so many misconceptions out there. There's so many half-truths, so many people that don't necessarily appreciate what the law does for them. No more worries on this show. We'll tell you what you need to know, of course, and be on the show. If something that I say, something that we discuss, triggers some questions, some issues, something else that you want to follow up on, it's very easy to do. You can call, you can email. We'll give you that contact information. I'm not just some guy who shows up on TV. I do this in the real world. I help people, so take advantage of that. But let me start off by telling you about a situation that came across my desk, because I think there's some important lessons to be learned. I spoke with a lady who had been off on a disability leave for over 6 months, legitimately with the doctor's note. She had a serious medical condition. Well, she got an email from her employer saying that, we need you to tell us if you can come back in the next 2 weeks, because if you don't, we're not going to have a job for you. So if you can come back in the next 2 weeks, fantastic. Otherwise, no more job. So, of course, she was very upset about that. She was working hard on getting better, and she called me, and she wanted to understand her rights. So let's take a step back and let's make it clear that she can be off legally as long as she needs to be off, so long as she has a doctor's note. There's no time limit as to how long she can be off, whether it's a month, a year, 2 years. There's no time limit. Beyond that, her employer is required to allow her to stay off work, to allow her to still be an employee while she's off. Now, the time that the company can assess whether they have a job for her is when she's ready to come back to work. If she's not ready to come back to work, that assessment can't even happen. So it's completely inappropriate for an employer to say, we're not going to have a job for you. They cannot know that. Maybe she's not going to be ready to come back to work for another 6 months or a year. How can they know they're not going to have a job for her? So by jumping the gun, by telling her that we're not going to have a job for you, that is potentially a human rights violation. That could be a wrongful dismissal. It's illegal. So what happens if you need to be off work, get that doctor's note. You can be off as long as you need to. Stay in touch with your employer, update them every once in a while. And when you're ready to come back to work, your employer has to make all efforts to bring you back at that point. If they tried at that point and there's legitimately nothing, then and only then can they let you go with your full severance. If anything I said here is not what your employer is doing, you have to call me right away.
How about the employers sometimes say, okay, we understand you got to be off a little longer. We'd like you to come back. What's wrong with you? Tell us we need to know everything about your medical file.
You know, John, for some reason, and I'm not kidding, I've been getting this exact situation so often very recently. Employers demanding to know what the medical condition is, demanding that your doctor fill out forms saying what the condition is. Well, let's be very clear. Your employer does not have a right to know what your condition is. Whether you have a bad back, maybe you're suffering from anxiety, it doesn't matter. What matters is whether you can work or you cannot work. So for an employer to try to say, I need to know what the condition is, I want to assess whether I agree with your doctor. Nonsense. They can't do that. They can't question your doctor. They can't ask what your diagnosis is. That's completely offside.
And how about when you do come back, hopefully eventually sooner than later, the whole concept, well, not a concept, it's something they have to do, and that's accommodation. Quite often employers don't quite understand how far they have to go legally, right?
So it's a very high standard that the employer has to meet. If you need accommodation because of your medical condition, maybe it's modified hours, modified duties, maybe it's the ability to work from home, your employer has to make that happen. It's not up to them. It's not up to them to say, well, we don't want to. If there is any possibility of doing that, they have to. If they don't, that's a human rights violation. And if anyone here is dealing with an employer that doesn't accommodate, they have to call me right away.
The website, always good to use, employmentlawyer.ca. That's where we want you to go anytime. You'll find a list, or at least across the country, pretty much where we host our radio shows. Tune into one, call the show. We're always inviting everybody right away. As soon as we get on air, give us a call. We know you've got questions, and we keep them, right? We answer them, but we play them back on this show. Our first call for the day. Lior's coming up right now.
I was working with this last company recently. Through a text message, he just basically said, I want my stuff back, and that was it. Like, he wouldn't even pay me for some of the stuff that I have done.
But how long did you work there for?
About a year.
And how old are you?
I'm 37.
What work were you doing specifically?
I started as security guard, and made up the supervisor, and then he made me operation manager.
Or deducting taxes off your pay?
No, we were...
Contractors?
Yeah.
Not smart.
Not smart. Well, forget about that. Not legal.
Yeah.
Let's be clear on this situation. This person has been misclassified. He works for a company exclusively. He's a supervisor. He is an employee of that company. It doesn't matter if the company withholds taxes or doesn't. It doesn't matter what the company calls him. If he looks like an employee and he acts like an employee, you got it. He is an employee. And because he's been misclassified, he has the rights of an employee. Of course, he has the right to get paid for his time. It's illegal not to pay someone. But beyond that, because he's an employee that's been misclassified, he's also owed severance. Same with you, by the way. If you've been misclassified, you're owed severance. So the question, of course, now becomes, how much severance is he owed now that we know he's an employee? So I'm going to take you, as I always do, to our severance calculator tool. You can find that, of course, at pocketemploymentlawyer.ca. And let's see how much severance this person is owed. So we know that he's been an operation manager. He's an employee. I've already said that. He's been there a year only. He's 37 years of age. You can see that he's owed as much as 4 months severance. He is an employee. He is owed severance. And by the way, you can find out yourself how much you're owed in that same situation or in any situation by going to pocketemploymentlawyer.ca.
Interesting one. You think most people, okay, he's been there a year, maybe gets, so if any, he'll get a week, maybe 2 weeks severance. 2 to 4 months is way beyond what the average person on the street would even figure he would get.
Absolutely. That is one of the biggest misconceptions. I started off the show today by talking about misconceptions. One of the biggest ones is that a short service employee doesn't get a lot of severance or any severance. Wrong. Short service employees have significant entitlements, actually disproportionately more than they have if they're a longer service employee. So you have a short service employee that's going to be owed severance in months. Almost always that's the case. So if someone is a short service employee, 6 months, 2 months, a year, they have to give me a call if they lost their job.
Phone call number 1 was awesome. Thank you so much for that. And phone call number 2 from our radio show is coming up right now. Let's have a listen.
I was in this situation a while back, and I got terminated after a long-term job, and I phoned up even labor relations, and they said it's 8 weeks max severance, regardless of how long you've been at a company. And your guest said 24 months, so I'm wondering if there's a specific situation that makes it 24 months. I phoned up labor relations, and they said 8 weeks max, regardless.
Again, back to the genesis why we started the show a dozen years ago, right?
Yeah, John, too bad that this is only a 30-minute show because I could speak on this topic for the next 2 hours. So let me be very clear. When it comes to losing your job, you cannot go to the government. You cannot go to the Ministry of Labor, the Labor Board, when it comes to your severance. The reason for that is the government can only advise you with respect to your minimum entitlements. That word minimum is key. Your full entitlements, your full legal entitlements are a lot more than the minimums. But the government only advises with respect to the minimum. So yes, it's true that after 24 years, his minimum entitlements were 8 weeks. His full entitlements, his full legal entitlements could easily be 18, 20, 24 months. So when it comes to losing your job, cannot go to the government. Not now, not ever. You're better off doing nothing than going to the government. Call me. You don't like me, call another employment lawyer because your full entitlements are significant and the government cannot advise on that.
Let's get into a short pause. On the other side, we'll get to phone call number 3 and then common myths about the termination process. That is all coming up. In the meantime, reach out to Lior, employmentlawyer.ca and 1-855-821-5900. We'll continue momentarily with more of the Employment Law Show. Stick around. People think you have to sign back a severance offer by a deadline. Employmentlawyer.ca says that is a myth. Deadlines are used as a pressure tactic. Make sure the offer is fair before you sign. Always check with the employment lawyer first at employmentlawyer.ca. Can insurance companies deny long-term disability claims for mental illness?
When you're suffering from a mental health disability, insurance companies just don't understand. But we do.
They can absolutely not force you back to work. If your doctors say you are not ready and you know you're not ready, they cannot make you go back to work.
If you have a mental health disability and your claim is denied, don't give up. Give us a call and let us fight for you.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you aren't owed severance pay if you are fired for a reason. Employmentlawyer.ca says that is a myth. Most for-cause terminations are false, and you are still owed full severance. Always check with the employment lawyer first at employmentlawyer.ca. All right, welcome back, Employment Law Show. Good to have you along for this half-hour journey. We'll learn lots. If there's questions at the end of the show you want to reach out to Lior and the rest of his team, you could do so. 1-855-821-5900. Help at employmentlawyer.ca. And the website, use it, get familiar with it, and you'll have access to that severance calculator, which Lior can do in his head really quickly, but you can do it in 30 seconds with the app on the website. pocketemploymentlawyer.ca is where you'll find that. Okay, as mentioned, phone call number 3 from our radio show is coming at you right now.
I've been a lead hand for my company for 14 years. Question is can the manager come to me after 14 years of being a lead hand and tell me that you are no longer a lead hand, I'm going to make you coordinator, and I'm going to take your pay away from you?
So it's not just a change in job, it's also reduction in pay?
Yeah.
How much of a reduction?
$5, maybe $7 an hour.
Yeah, you know, there's a saying that you like to use, which is a whole bowl of wrong. Well, this is exactly what this is. It's not legal. Your employer cannot just make significant changes like this to the terms of employment. We're talking about a demotion here. That's a big deal. Your employer can't do that. That's embarrassing. It's something that the company cannot do. It goes beyond the rights of the employer. Beyond that, of course, it's the pay cut. $5 to $7 an hour reduction, huge reduction. It's a massive reduction, not allowed. So what does that mean? Anytime we're facing that type of a significant change to the terms of employment, this concept of constructive dismissal should come to mind. What that means is you may be able to consider your employment as being terminated. Now, you can't physically stop your employer from changing the terms of employment, but what you can do is to treat that action, that change, as a termination, again, constructive dismissal, and require the company to pay you your full severance. Now, depending how long you've worked there, that severance can easily be as much as 2 years' pay. So whenever your employer is doing something that they're not allowed, they're changing your hours, your pay, they're demoting you, they're relocating you far away, you have to think constructive dismissal. Remember, you have to act very quickly on that, so give me a call.
Again, appreciate all the phone calls we play in the show, and thank you for making it happen. Again, radio shows can be found at employmentlawyer.ca for a station near you in the GTA here, otherwise across the country. Okay, main topic, Leo, let's get into this. Common myths about the termination process. Number 1, your employer needs a legitimate reason to terminate your employment. There you go.
So oftentimes when I get calls, people are upset, understandably, because they're let go and they feel that the reason that the company gave them is not legitimate, maybe it's not truthful, or maybe there's really something else going on, and they're upset about that. And I get it. I'd be upset as well. So would you. But from a legal standpoint, the company actually does not have to have a legitimate reason to let you go. A company, for the most part, can let someone go at any time and pretty much for any reason, so long as severance is paid. So if your employer paid you the severance that they owe you, that reason doesn't factor in. Maybe the reason they gave you is false. Maybe there's really something else going on. Maybe they want to hire their cousin and pay their cousin less. Not nice, not right, but they can do that legally. Where the illegality comes in probably 90% of cases, that most people are let go without proper severance. And that is what a wrongful dismissal is.
Number 2 myths we're talking about here when it comes to the termination process, right? You can be pressured to resign or retire by your employer.
Absolutely not. By definition, a resignation or a retirement is something that the employee does voluntarily and unilaterally. So the moment someone pressures you into doing something like that, it's no longer a resignation. It becomes a termination. If the company says, we insist that you retire or resign tomorrow, and because of that you do, you haven't acted voluntarily. The law considers that to be a termination. But what I don't want anyone to do is to retire or to resign because of that pressure, because it may be difficult later on to show that you only did it because of that pressure, because you were threatened into it. So what happens if you're being put pressure to retire or to resign? You very simply say, thanks, but no thanks, and you say that in writing. I'm going to continue working, employer. If the company wants to let you go, let them. They're going to have to pay you your full severance. What you're trying to avoid is a situation where you resign even though you don't want to, and then the company tries to avoid paying you any compensation, any severance. Avoid that. Always say no to retiring if you don't want to.
What if it's not that direct? What if it's a little more subtle? Like, hey, you know, your 65th birthday was last week, Lior. Have you been to Pebble Beach? Have you played golf? It's better than working. I mean, you've come across that, right?
It is better than working, in fairness.
Obviously, right?
But no, I have come across that. I've told you the famous story when the employee left brochures for golfing and retirement resorts on someone's desk.
That's not nice.
It's inappropriate. It's inappropriate to suggest that you're too old to be working or that you should be considering leaving because of your age. That's age discrimination. So if you're facing that, make sure you tell your employer in writing, stop. I am not retiring. I'm not resigning. If I change my mind, I will let you know. And I don't appreciate being pressured into it. If you do feel that you're being mistreated or pressured because of your age, again, human rights violation, you need to give me a call.
All right, again, we're talking common myths of the termination process. Number 3 is this: simple mistakes and performance issues can lead to a termination for cause.
So what is a termination for cause? Termination for cause is the death penalty of the employment relationship, and that means that because you did something so bad, so awful, that the company is allowed to let you go and not have to pay you any severance. That is unbelievably difficult, incredibly difficult to do, and it's reserved for the worst offenders. So no, it's not correct that just because you had some issues, performance issues, even behavioral issues, that you can be let go for cause. The question you have to ask yourself is, what I did deserving of the worst punishment? If it is, you stole, you hit someone, sure, yes, you could be let go then without any severance. But if there's a performance issue, you tried, you didn't meet the targets, if the company wants you gone, remember what I said, they can let you go, but they're going to have to pay you your full severance, as much as 2 years' pay. So no, in most cases, the vast majority of cases, when I see a company saying, we're letting you go for cause, you did something wrong, we're not going to pay you severance, that is wrong, that's a wrongful dismissal, and severance actually is owed.
So if you're on a forklift, you drop a pallet full of water bottles. A lot of people would think, oh, that's a fireable offense if it's your first time. Not enough, right?
If it's your first time, even if it happens again, so long as you're not deliberately doing this, as long as you're not ignoring what the company says repeatedly, no. There's other things the company can do. They can warn you, even in some situations suspend you, with pay, by the way, not without. And then and only then, if they've tried to do everything and you still do a bad job, maybe then they can consider a termination for cause, but very difficult to do.
Our last myth for the topic this week, guys, your severance package release must be signed and accepted as soon as possible. There, if you can, right then and there, right?
So let's be very clear. That's false. That's wrong on so many levels. Now, every severance letter that's ever been written, you'll see has right at the end of it a deadline. So here's what we offer you. And by the way, to accept this, you have to sign by Friday, Tuesday, whatever it is, or else. And that deadline, if you think about it, it can be very overwhelming to someone. You're going to feel the pressure. I better sign this. Oh, my gosh, this is a very difficult situation. I don't want to make it worse. And that's what it's designed to do. It's a pressure tactic. But here's the thing. No, that's wrong. Your legal rights don't expire on the date that your employer decided on unilaterally. The law says you have 2 years, 2 whole years to pursue your rights, 2 years before your rights go away. So that deadline is meaningless. Your rights don't expire on Friday. The company doesn't get to pay you less because you didn't accept on time, because the law determines how much you're owed. So take all the time that you need to consider it, to get your head wrapped around it, to get some legal advice. If it takes a week, 2 weeks, a month, that is fine. Do the right thing, because once you sign that offer, because of that pressure tactic, you can't get out of it. You only have one chance to do it right.
Thanks for those questions. Thanks for the answers, Lior. When it comes to the termination process and the myths, again, need more details, always call Lior. Another way for you to ask questions, and it might appear in the show, which we're going to do momentarily, that's terminationquestions.com. Terminationquestions.com. It's free and anonymous, and that's where we're going after our break right here on the Employment Law Show. Stick around. People think you should go to the government to get severance pay. EmploymentLawyer.ca says that is a myth. Government can only help you get minimum severance, but not everything you're entitled to. Always check with the employment lawyer first at EmploymentLawyer.ca. If your long-term disability claim is denied, should you appeal?
Appeals often fail because insurance companies control the process. So long as you appeal, you're playing by their rules.
You should never appeal the denial of your disability benefits. Appeals are just a mirage of false hope.
Don't. That's their process. Take it out of their hands and fight for your rights with our help.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think their employer can make changes to their job. EmploymentLawyer.ca says that is a myth. Your employer can't change your pay, hours, or duties. You may be entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca. And welcome back to the Employment Law Show. John Scholes, Lior Samfiru. Always reach out with any questions. Don't sit and wonder. There's answers out there, and they can be had quickly and concisely. Simply make that phone call. There's your first step, 1-855-821-5900. You can email help@employmentlawyer.ca, and you can go to terminationquestions.com. That's a great place to ask any questions, and they might appear on a future show. Just like this one, Lior. Here we go. Tuck in and ready with your answer. I'm currently on maternity leave, but it will end in a matter of weeks. My employer has recently informed me that my position has become redundant and offered me another position with added responsibilities for the same pay, much longer commute, non-flexible hours. I was told I would be fired if I did not accept this offer. Do I have any options here?
Oh gosh, John, is it really only a 30-minute show? Can I take a long time to answer this? Because it's just wrong on many levels. But I'm going to break it into two parts. Number one is the idea that your employer has to do everything possible to bring you back to the same job that you had before your parental leave. Now, in some situations, something unexpected happens out of their control and the job doesn't exist. In that case, maybe they're allowed to look for something else. But right off the bat, I'd be very concerned, why is the job not existing? Is someone else doing it? Did the company restructure because they didn't want the person back in that role? Under employment standards, under human rights legislation, the company has to bring you back to the same job, same pay, same everything, as long as that's even feasible, even remotely feasible. So that's the first issue. Second issue, let's assume for argument's sake that legitimately the company does not have that job. That job no longer exists. They've tried, and it's just not possible to bring you back. If they offer her a vastly different job in terms of hours, in terms of pay, responsibilities, shifts, well, that can be a constructive dismissal. So no, you don't have to accept a very different job. In this case, she says the hours are going to be different. They're going to be less flexible, a lot more responsibilities, a further commute. No, constructive dismissal, not legal. So even if we get past the fact that the old job doesn't exist anymore, with this new job, constructive dismissal, meaning she can't just be forced to accepting it. She can treat that as a termination, get her full severance right away.
You can join Lior, by the way, anytime on the YouTube live stream on Facebook and YouTube as well, at ST Lawyers. At ST Lawyers is how you do that. And for the show today, Lior, here it comes. Says, I've worked for a company for 4 years in a sales position and was just let go. They've offered me 2 weeks of severance. When I pushed for more, HR stated the financial difficulties the company was experiencing made this impossible. Is that true?
Well, no, it's not. Because guess what? There's no discount for financial concerns. There's no discount because the company may be struggling financially. This is not because I said so. That's not because I'm insensitive to companies' needs. It's just the way the law works. Just like a company can say, well, we're going to pay you less than minimum wage because we're struggling, they have to pay their full severance entitlements. And if they can't, that means they can't operate. So the company has to find a way to pay severance. Unless they're in a bankruptcy proceeding, which case it's bad news for the employee. Even if they're struggling financially, they have to meet the obligations under employment law. That means paying full severance. Now, this person, after 4 years, was offered 2 weeks. They could easily be owed 6 months, 8 months. And the company that let them go has to find a way to meet that obligation. So remember, the excuse or the reason we just don't have the money, or we're struggling, or business is tight, it's not enough. It doesn't extinguish your employment law rights, certainly not when it comes to severance. What it does mean, you may have to act quickly on this. So if you're ever in that situation, call me.
And this being a sales position means all components of the compensation, an average of their commissions, maybe they have a phone, a car, you don't know, right?
Yeah, certainly with salespeople, but not just, of course. There's several components of compensation. You touched on them, commissions often, whether it's some of your compensation, all your compensation, there's other, maybe a car allowance, a phone, etc. All components of compensation have to be accounted for with respect to your severance. It's not just your base salary. Benefits as well, pension contributions, RSP contributions.
Bonuses maybe, if there's any.
Bonuses. Yeah. So if you want to know if something should be included, you ask yourself, would I have received it had I continued working? And if the answer is yes, I would have, it has to be included as part of your severance.
As we wrap up every show and during the week, it's time for Employment Rights Rapid Fire. So let's get into that. Okay, here we go. I throw these at Lior, answers them quickly, concisely, and hopefully correctly. I'm kidding, he answers everything correctly. If it worked the other way, then we'd have a problem. Okay, rapid fire question number 1, Lior. Your employer can force you to return to work after a certain number of sick days.
Absolutely not. That is false. The number of sick days that you have nothing at all to do with how long you can be off work. Now, the number of sick days may dictate how many days you're going to get paid by your employer. But you can be off 10 times that, 1,000 times that, if that's what your doctor says. So no, you cannot be forced to return back to work when your employer wants, or based on the sick days. Only your doctor can decide that.
Your flu can only be around for 10 days. That's the only time it can be around.
Otherwise,
it's got to get better.
No, it doesn't work that way. I wish it did. It'd be nice if you knew how long you're going to be sick. Unfortunately, for most people, it's a moving target, and that's why you can be off as long as you need to.
Rapid fire question number 2. You can and should file a complaint with the government regarding unpaid wages.
So I got on my soapbox earlier and I said that you cannot go to the government when it comes to your severance. You cannot go there. You cannot ask for help with your severance when losing your job. But what is absolutely true is you can and you should go to the government when it comes to money that's owed to you by way of wages. If the company didn't pay you for your salary, for your vacation pay, for your overtime pay, for that you can and should go to the government. They can help you with that. So unpaid wages, yes. Severance, absolutely not.
And pocketemploymentlawyer.ca in that regard as well, right? Rapid fire question number 3. We're going to keep going here. Certain industries and workplaces can implement unpaid training.
No, there is no such thing as unpaid training. That's false. If your employer is asking you to do something, if they're requiring you to do something, that has to be paid. They have to pay at least minimum wage or whatever an employment agreement says. There's no such thing, John, as unpaid training.
Next one here is your employer can schedule your vacation paid time off. This one may surprise a lot of people.
It does, and I saw this a lot during the pandemic, and I've seen it since. Yes, your employer is actually allowed to decide on their own when you're going to take your vacation. Now, most employers don't do that. They don't want to tell you you have to take your vacation in April or January, but they can. Most employers will let you choose, but legally, if your employer says, I've decided when you're taking your vacation, it's not going to make you happy. But they can do that legally.
But if they go back on their word and you've already bought plane tickets, that's a problem, right?
It happens, by the way. We said yes, but now we've changed our mind.
Yes.
If you've done something in reliance on your employer's approval, they cannot take that back.
One more before we're done. Overtime pay can be refused if your employer did not approve the extra time, the overtime.
No, your employer cannot refuse to pay you for overtime. If you work the overtime and it was legitimate, the company has to pay for, even if they didn't approve it. And by the way, John, even if they said don't do it, they still have to pay for it.
Rapid Fire is done for another week. Thank you so much for tuning in. Again, as we leave you here for another week, feel free to reach out to Lior anytime and his team. 1-855-821-5900. help@employmentlawyer.ca. And that website, use it. It's free. It's anonymous. Severance calculator. And that is pocketemploymentlawyer.ca. We'll catch you next time right here on the Employment Law Show.